evidence, what we do with evidence after the trial of the case. So that, and I mean, I still have an issue of that, because you would have still had to return his property to him.
Your Honor, I'm sorry, I have to respectfully disagree with the court here. It's not a situation of what Mr. Steele challenged at the previous motion. It's what was ruled upon. There was no ruling upon the.
So if I had $200 and this situation happened, you wouldn't have to return the $200 to me if I won my motion to suppress?
Your Honor, if I had a search warrant that was valid, currently being executed for your $200, and it was for a separate investigation, a separate case, my position is that no, I would not have to return it until that separate investigation, that separate case was done, because I had a valid search. And obviously,
do you have some case law that interprets 17-5-30 in terms specifically the possession of which is not otherwise unlawful? Because that to me says that would be any contraband, weapons, or things that you're not required to, not allowed to otherwise possess. But it doesn't distinguish on investigations or you holding on to evidence that otherwise should be returned.
Your Honor, I don't have a ruling at a case at this time. I'm happy to provide that in a supplemental filing. But again, my understanding of the law is and has been that where there is, if a search warrant is currently being executed on a cell phone, for instance, the police are allowed to retain that property as part of an ongoing investigation.
But he won the motion to suppress.
On the marijuana case, Your Honor, not.
But you took more than the marijuana. He wouldn't get the marijuana back anyways. He wouldn't get any cocaine that came back anyways. He wouldn't get a gun back if he's a convicted felon. But anything else that was proper, that was taken from that particular, house subject to the warrant, is not otherwise illegal, is returned. The 17-5-30 says shall return and not be subject to further prosecution, because that's the whole thing about it is you don't get another bite at the apple based on this particular evidence. You can go ahead and do some, a separate investigation or whatever, but this evidence is supposed to be returned to the defendant.
Your Honor, our position remains that because there was a separate ongoing investigation for which a valid search warrant was in effect, and it was not, there was no ruling as to fruits of the poisonous tree, there was absolutely no reason to return that cell phone. I'm happy to provide the court with an additional brief, but that is our position at this time.
Okay. All right. I'm going to take 5 minutes, okay?
Thank you, Your Honor.
Okay. All right. We're going to